Professor, thanks so much for taking the time. I appreciate it.
Thank you for having me.
Now, you've written a ton about affirmative action over the years. What is your view on the recent Supreme Court decision in SFFA versus Harvard?
A ton may be a bit of an exaggeration, but regarding the Supreme Court decision, I think it's basically correct. Even if you think that some kind of affirmative action may be legal, the kind that we saw at Harvard and the University of North Carolina, and also many other institutions, just can't possibly be because they're using these extremely vague and crude racial categories to try to determine who's eligible for affirmative action and who isn't. Like, for example, the Asian category actually encompasses more than half of the population of the world, and the categories like Black, Hispanic, and others are equally crude. In addition, the claim that they achieved the benefits of so-called educational diversity, which is the official rationale for these programs, it is, as the Supreme Court pointed out in their opinion at length, extremely vague, difficult to measure, and also difficult to tell to what extent, if any, these preferences really are achieving these benefits. And so if you look at it, if you believe that racial classification should get any kind of significant judicial scrutiny at all, this kind of thing can't pass. In addition, even if you think that it's permissible under the Constitution, Title VI of the Civil Rights Act of 1964, which applies to all educational institutions that get federal funds, it categorically bans all racial discrimination. It doesn't make any exceptions for affirmative action. There are previous Supreme Court decisions which say, well, the standards under Title VI are the same as those for the 14th Amendment, but those decisions are extremely poorly reasoned. They're so bad that I think Justice Gorsuch was justified in his concurring opinion in saying that maybe those precedents should be overruled or limited, so you could just apply the plain text of Title VI, which if the Supreme Court had done that, would have made for a much simpler decision that wouldn't have required 237 pages of opinions that we actually got.
Now, you know that the justification for these types of policies is the history of the US and the sometimes obviously very difficult racial inequities that this country has been engaged in for decades. What's your position on the idea that affirmative action works to rectify these things? That is the argument.
So that argument is a better argument than the one that was actually before the Supreme Court, which was, as I said before, the diversity rationale. That rationale was used because it dates back to a key opinion in the 1978 Supreme Court decision in the Bakke case. The compensatory justice rationale that you mentioned is a better one, but it runs into several problems. One is many of the people who benefit from affirmative action today, it's hard to argue that they're truly victims at any kind of massive scale of the kind of historic injustice you mentioned, as many of them are either post-1965 immigrants to the United States or children thereof. And whilst these groups certainly have suffered some racial prejudice, it's hard to argue they've gone through injustices comparable to slavery, Jim Crow, or the like. A second problem is that many of the victims of affirmative action also belong to groups that have a history of being discriminated against, most notably Asian Americans, who are among the biggest victims. And in some cases, including Harvard, there is even evidence that part of the policy was to try to limit the number of Asian American students over and above the way that any students who are not in the preferred groups get disadvantaged by these policies. Finally, there is this even deeper philosophical problem, which is that if not for the history of injustice that occurred, none of us or who currently exist, whether white, Black, or otherwise, would actually be here, because history would have taken a vastly different course, and the same sperm would not have met the same egg at the same time, which means that a wholly different set of people would have been produced. And therefore, it's just simply impossible to say, let's rerun history in such a way as to get the world that would have existed absent these great historical injustices, because if somehow we could do that, that would mean none of us would actually exist. Now, I hasten to add, this does not apply to situations where you're actually compensating a person who directly and personally suffered the injustice in question. So, for example, the US government was absolutely right in the 1980s to compensate the Japanese Americans who were interned during World War II in detention camps. And if anything, the problem was they were paid too little compensation for the wrong they suffered. But if we're talking about somehow compensating today's African Americans for the legacy of slavery, Jim Crow, and other historic discrimination, it just simply cannot be done because trying to unwind that history would lead us to contemplate a world where virtually none of the current population of the United States actually exists.